So recap of what we talked about last time. So in class 2, we continued our discussion of the Londoner and bimetallic cases before turning to Goldberg versus Kelly, which was our first sort of core due process case. And so Londoner and bimetallic, as we discussed, set up this distinction between adjudications and rulemaking in the context of deciding due process claims, although this is a distinction that is going to be important throughout the course in a variety of contexts. And so in Londoner, the court had said there was no due process right to a hearing, or sorry, that there was a due process right to a hearing before a board could change the assessed value of a piece of property for property tax purposes. But in bimetallic, the court says that does not apply when the property values for the entire city are being adjusted. And so why would that rule be different? So it's not super clear from the text of the due process clauses what the difference would be. They're both government actions. They both deprive someone of life, liberty, or property seemingly to an equal extent. And it seems like that the due process might be the same. So what is different in those two cases? So a few possibilities. One is maybe a legislative action in some sense doesn't deprive anyone of life, liberty, or property. Or maybe something that affects the community as a whole or a really large number of people is sufficiently protected by the political process that the due process clause does not apply. So if the city government raises taxes for everyone too much, you'll vote out the city council and the mayor and stuff. So maybe the due process clause doesn't apply, or maybe we could say that the due process clause applies because it's still government action, it still deprives someone of life, liberty, or property, but that the process that is due is the legislative process, is the political process. Practical differences, maybe the facts that we want the board to consider are different. So assessing the value for one piece of property or a small number of pieces of property will turn on the kinds of things that would come out in an individual hearing. Like, is this piece of property close to this road? Is it going to be more valuable because of the road? Is there a chance that it might hurt the value of the road, right? As opposed to the kinds of facts that would be relevant for the values of the property citywide might be like, what's the total tax revenue of the city? What's the total expenses of the city? How does it compare to other cities? Things like that, that aren't the kind of individual facts that might come out in a hearing. Maybe we're worried about corruption or government mistreating disfavored groups. So if government can assess property values higher only for the groups that the city is trying to, suppress in some way, then maybe we need a hearing to protect against that. Or maybe it's just a matter of practicality, right? So you can't give everyone a hearing so you don't need to. Might be just this very real policy type of decision. But whichever of these we wind up latching onto and agreeing with, the bottom line that comes out of this case is that government has to provide an individual hearing when it's doing an individualized action, or some kinds of individualized actions. We will see that the specific process that is required is going to vary. But when it's doing something for the community as a whole, it doesn't. And so this sets up the distinction between rulemaking and adjudication, and it is not a super clear line. So we looked through some examples last time where you can make arguments on both directions, and we disagreed as a class. And then when we talked through the discussion problem on HUD regulations, we saw that of the different kinds of factors that the court might look at, none of them are especially predominant. Instead, courts tend to look at all these things together So things like rulemaking tends to be prospective. It tends to be more general. It tends to apply to large numbers of people. It tends to depend on social facts about the community as a whole. It tends to precede adjudication, and it tends to be protected through the democratic process. Whereas adjudication tends to be more retrospective and specific and apply to a small number of people and follow rulemaking. So often you'll have a rulemaking and then an adjudication applying that rule, and be susceptible to discrimination that might not be remedied through the political process. So based on Londoner and bimetallic, it kind of looks like if you're an agency, you prefer that your actions be characterized as rulemakings because then you don't have to provide due process. But as we saw in the HUD example, that's not always going to be the agency's preference, because in that case, the agency really wanted it to be called an adjudication, because although then there wouldn't be due process rights, or then there would be due process rights, there wouldn't be procedural rights under the statute that they would have to comply with. And so that was a case where the agency preference was that something be classified as an adjudication. So it's going to be highly contextual whether, if you're the agency, you're better off if something is classified as an adjudication or a rulemaking. Then we turn to a series of cases that are going to take us a couple of days on just due process as due process. And so we started with Goldberg v. Kelly, which is the first of a line of cases that are about this question of what counts as life, liberty, or property. We're then going to have some cases about what counts as due process, what kind of process is adequate. But so for a long time, the rule about what counts as life, liberty, or property was pretty straightforward, even if it didn't really have any principled basis, which was that if something was a right traditionally protected by the common law, so by the law of property or by the law of contracts or maybe by the law of torts, then it was a right protected by due process, whereas other things that were created by statute were mere privileges that are not protected. And so Goldberg v. Kelly comes along and wipes that out entirely, changes all of that, does so in kind of this odd way because the government hadn't even argued the privilege point there, they sort of conceded it. But the court there says welfare payments are a property right protected by the due process clause for two big reasons. One, the recipients of them are highly vulnerable. The benefits may be their most important form of property. And two, society as a whole has evolved to the point where government benefits are an important source of wealth, not only to the poor, but also to the rich. So the court points to like medical licenses, legal licenses, broadcast licenses for TV stations, all these government handouts. And so basically says like, if we say that the only form of property that we're not going to protect is the one that poor people get, that's a problem. And so the dissent goes after, in particular, the second point, saying that it's a bad sign for society if government handouts have become the major source of wealth. But maybe more importantly, the dissent makes this empirical point that this is not actually going to make the poor better off. Because if government is willing to spend a fixed amount of money on welfare, and there's no reason to think that this process will mean people will want to spend more on welfare, then every dollar you spend on process is a dollar that you're not giving recipients. And every time you make it harder to take someone off welfare, you give states a strong incentive to make it harder to get on welfare in the first place. And so empirically, we've seen some studies that suggest that these concerns may have been correct. That in terms of total dollar amounts, that states became less willing to put money into welfare after this decision. But so it's a decision anyway, and it sort of represents this shift from this old property regime to this new property regime of government can create property rights that are then protected by the Constitution, where the court's trying to assure people that if you rely on government benefits, you're not going to be treated too arbitrarily by the government taking them away. And so today we're going to wrap up Goldberg in a few minutes by talking about the limits of the decision and about the second part about what process has to be provided. And then we'll turn to a series of cases that sort of set the boundaries of this new property regime about what kinds of things count as life, liberty, or property. Before that, what questions can I answer? Yeah.
It's just something in like your recaps that you were saying.
Can you yell a little louder?
Yeah. So you had said like talking about how like government has to provide individual hearings when it's taking an action like on the individual. But I guess sometimes like when we're talking about hearings, I think in the back of my head, like the town hall meetings, I'm not really involved in like any sort of like city government stuff. But in my mind, I guess I don't know if like hearings where multiple members of the community can all come in and participate at the same time also factors into these kind of things, or if it purely has to be like one person's showing up at a time talking about their specific situation.
So the question, if anyone couldn't hear, is how do we think about like when the city has like a town hall or an open forum where multiple people can come and present? That basically the question, is that a hearing for this purpose or not? The answer is that probably does not count as a hearing, although we're going to have some cases about how we decide what the like contents of the process are. But those are typically not considered adjudications. Those are typically the kinds of things that an agency will do sort of on the way to rulemaking in some sense, right? So like the FTC has been in the news a little bit recently, the Federal Trade Commission, which enforces a whole bunch of statutes, but among other things, enforces the prohibition on unfair trade practices. They've been in the news a bit recently because they're having their first sort of open hearings in a long time where people can come and give that kind of statement, things like that. And those are not part of an adjudication. Those are part of the commission considering potential rulemakings. So that stuff is stuff that can be done sort of voluntarily by the agency, or there might be some requirement in the statute to do that, but it's not going to be required by due process. Does that make sense? Other questions? And then like, can you have like, you know, a hearing where people do have a right to a hearing, but it can be kind of seriatim, think like traffic court where everyone kind of gets 5 minutes to stand up and say whatever. Yeah, that might be good enough as a hearing under the due process clause if the court said that kind of process was sufficient. And we'll see what the standard is for that in a few days. Other questions? Okay, so turning back to Goldberg versus Kelly, we're speaking to Mr. Marshall, Mr. Ozenbaugh, and Mr. Spencer on this. Just a couple of last questions on this. I do want to talk a little bit about the sort of second half of the decision. So the first half is, yes, taking away welfare benefits is taking away your life, liberty, or property. And then the second half is going to be saying, therefore, the process that's required is an individual hearing. And it has to happen before the person loses the benefits. The timing matters. So why does it have to be a hearing? Why not just paper submissions? Remind us, I think we referenced this a little bit last time, but just remind us. Yeah.
Is this from this decision that's cited on 360 Green versus McElroy?
You're going to have to speak up a bit.
It's the decision on 360 Green versus McElroy to face your accuser.
So the facing your accuser thing, though, is a criminal law concept for the most part, right?
Yes.
and this is not a criminal case, we might say by analogy, you therefore have the right to face them, but like, it's facing them in some sense to do it in writing, right?
Well, what we talked about on the first class is that like hearing in person ensures that they actually hear you. Like it's pretty easy to just rubber stamp something that's submitted in writing and say that you considered it without actually considering it. And also another thing to consider is the relative sort of, I guess, ability of any given person to cogently write in person or write, you know, their reasoning for whatever the hearing is about, as opposed to speaking in person.
Yeah, so the court talks about the opportunity to be heard must be tailored to the capabilities and circumstances of those who are to be heard. And then basically like written submission might be really unrealistic, implausible for a typical welfare recipient who may not have very much education, may not have very much time. Less flexible than oral argument, right? So that concept that the opportunity to be heard must be tailored to the circumstances is going to be really important in this last prong of what is the process that is due? Where if you're dealing with like a big company, the opportunity to submit something in writing may be totally reasonable because the big company is going to have good lawyers who can write well and, you know, they're not going to benefit to the same degree from an oral presentation as a welfare recipient, maybe, right? So the takeaway from this case is not anytime you have an adjudication, anytime you take away property, you have a right to a hearing. It's that you have a right to due process. And the process that is due is highly contextual. Here it's a hearing, but as we'll see in a few cases, like the court almost immediately backs away from it. Okay, so back on this concept of what counts as life, liberty, or property. What happens if Congress changes the law so that you can only get welfare benefits for 2 years? And then they go away. They did this in 1996. When they go away, then do you have a right to hearing?
I'd say no, because at that point it's a rulemaking, not an adjudication.
No, because it's a rulemaking. So it's still government action, right? It's still depriving you of property. But the thing that's depriving you of it is not some decision of a bureaucrat that you are going to be taken off the rolls. It's the 2 years have passed, and that was a decision by the Congress, right? So yeah, no process would be due there. That would be a legislative change, not subject to due process. It would change the nature of the property right in some way, right? Because the property right there is being defined by Congress. What if Congress changed the rules so, setting aside the 2-year deadline thing, there's still no deadline, but they added, a clause that says welfare is an affirmative grant, not an individual entitlement. You have no property right in your welfare benefits. But otherwise, it's substantively exactly the same as before. Yeah.
So in the case that the court has already ruled for it, wouldn't it be trying to overrule the court's decision? And wouldn't that be unconstitutional?
So the court has already ruled that you have a right to a hearing.
So it had ruled that you have like a right to, that benefits are a right and not a privilege, right?
The courts have already ruled that benefits are a right, not a privilege. But that right is the right as defined by the legislature, right? So can the legislature change that definition?
I mean, I think arguably they could, but it seemed like in this case, the court wasn't saying specifically that the statutory right was a property right. They were kind of jumping together, life, liberty, or property all together.
So
it doesn't
maybe it's
seem
not
like-
about property, it's about this phrase that is sort of a term of art, life, liberty, or property.
Yeah, or like grievous loss in this case.
Maybe.
Arguably, that could go to life or liberty.
And so if Congress says no individual entitlement, it doesn't change whether it falls within life, liberty, or property, because maybe it's still life, liberty, or property.
I mean, I'm tempted to go with Josh on this, but the argument that I would make is that the property right arises out of your eligibility. So if Congress can say, if Congress can make rules and say you're simply not eligible at this point, then you don't have property right.
Well, it wouldn't be a rule that says you're not eligible. It would be a rule that says,
Nobody is eligible.
well, you're still eligible. It's just you have no individual entitlement, but we may still give you the benefits out of the goodness of our heart. It's a little weird because it just seems like it's a loophole to get around this decision, right? And so it's not clear what the court would do, because it might still look at the sort of overall statutory scheme and say, well, it says it's not an individual entitlement, but it still says you get benefits if you do X, Y, and Z. And so it's still effectively a property right. Congress actually did that in the 96 law, but we didn't get the courts deciding this question because they also set that 2-year time limit. So, okay, last question before we'll turn to Wisconsin and Paul v. Davis. What if you apply for benefits and are wrongly denied them? Is that a due process violation?
I would say no, because you're not entitled to the property at that point, or you are not in possession of those rights at that point. So I would say, no, due process does not apply at that point.
So you're not entitled to them. Although, I mean, if the statute says like, you know, if you make less than X dollars per year, you can get welfare benefits, and you in fact make less than X dollars per year, you might be legally entitled to them. They just haven't started granting them to you yet, right?
Right, but I think that what the court tried to make clear was that if something is promised to you or something is granted, in other words, then in that sense, you have that property right. But just because you're legally entitled to it does not mean that you're actually given that right and now it's being taken away from you. So you should be.
And so we might fit that into the constitutional text by saying that if you haven't been given the property in the first place, not giving it to you, even if that's legally wrong, is not depriving you of it in the way that taking it away from you would be. That's plausible, yeah.
I also think it would change the way, because the court also talked about balancing the government's interest in not spending the taxes and then the damage or injury caused to the person by sudden retraction of the funds that might be necessary for sustaining themselves, acquiring medicine and what so on, because they're already in need of it.
Yeah, so the court was very struck with the potential risk of just taking away benefits that someone's expecting, right? That might like cause their life to spiral out of control or something, right? Versus this where you haven't been getting them yet. Maybe it's not going to cause the same disruption. Plausible. Anyone want to make the argument that it would be?
If you are entitled to them, I think not getting them, falsely not being given them would be a denial of due process. Like I don't agree that if just because you had them and had them taken away, that's somehow significantly different than wrongfully not having them.
So it's sort of like we're interpreting the word deprives, right? Where if you're legally entitled to it and they don't give it to you, that is in some sense depriving you of it, right? So this one is hard. Courts are actually split on this. The Supreme Court hasn't definitively weighed in, but the circuit courts are divided on it. And the arguments on the two sides are exactly what we've just said, right? So maybe if someone's legally entitled to it, not giving it to them is depriving them of the right. But on the other hand, that doesn't seem to be the court's major concern. And the government interest in not providing a bunch of hearings when people just apply and are denied and maybe most of those denials are correct, maybe very high in avoiding that burden.
Well, is there another avenue to go if you are denied to get those benefits?
Maybe, maybe not. Apply again in a month with more paperwork, I don't know. I mean, we've seen sort of similar problems in the last, during the pandemic with state unemployment lines that, you know, like you just call and you're on hold for 18 hours, right? Where it's impossible to do the physical act of applying. Now, is there anything else to do? Maybe not. Okay, so bottom line of Goldberg, the critical importance of the case is going to be in this first holding that welfare benefits are property rights or are life, liberty, and property that are protected by the due process clause. This shift from old property to new property is the critical part here. The part about what process was due is going to be almost immediately sort of watered down in subsequent opinions. So for welfare benefits, it was never explicitly overturned, but in '96, Congress changed the law in a way that meant that it was less relevant. And I'll just highlight that the court didn't seem super concerned by this concern in the dissent that Democratic policymakers will just, you know, spend the money on hearings instead of on welfare benefits, and that might in fact hurt recipients. But that might be a significant factor here. So every time we have some kind of due process claim and some kind of right to more hearings and more process, that's going to impose a bunch of costs that the courts tend to ignore. And so keep that in mind as we talk about these cases going forward. Okay, questions on that before we turn to these two cases on when government says nasty things about us. Thank you, Mr. Rosenbaum, Mr. Spencer, Mr. Marshall. Any questions on Goldberg? Why don't we take our break now, because we're almost at the halfway point. And then we'll come back and we'll talk about Wisconsin and Paul B. Davis. 10 minutes. Okay, so I want to talk about these two cases together because they kind of form a nice contrast, and so we can compare. So Wisconsin versus, the best I've done is Constantino, but I'm not sure. Starting with that one, we've got a police chief who says, or who puts up a sign says, this person is a habitual drunkard and therefore can't buy alcohol for a year without a hearing. So Ms. Lumi, Ms. Nagamoto, Mr. Schutte, just starting with the first question that we always start with, what's the agency, what's the statute, and what are they doing that implicates due process?
It's the state of Wisconsin, and it just says it's a state statute. You refer to it as the act.
So there's a Wisconsin statute that lets, who does it?
Anyone authorized by the statute.
But here, who is it?
Oh, the Hartford police chief.
So it's a police chief or sheriff or something, yeah. And what's the life, liberty, or property interest that they're being deprived of?
The ability to purchase alcohol.
So is that what the plaintiff here or Constantino, the respondent to the Supreme Court says?
Well, she says that they deprived her not only of being able to buy alcohol, but that it, in doing so, it gave her a stigma of being a drunkard in the community.
So there's sort of two possible arguments here, right? One is the right to buy alcohol. And the other is the stigma or the reputational harm of the government labeling her a habitual drunkard, right? And so the Supreme Court says, no, you can't do this without a hearing. What exactly can you not do, or what is the constitutional problem with that, according to the court in this case?
It was posted in the liquor stores without residents having any process at all, and they're not afforded any chance to defend themselves.
And why is that a problem? Lots of things are posted in liquor stores without anyone getting a hearing, right? Like, they put up an ad for liquor and without asking me, that's a problem in my mind, right?
Yeah,
Like, they should ask me what I think of that.
they specifically cite that, they could have been a victim of an official's capriciousness towards them.
So they could be the victim of capricious action, meaning sort of arbitrary action, right? And what are they being deprived of?
They say that even though it's not a literal deprivation of life or liberty or property, it's a grievous loss to the person
Why?
because of their like reputation, their good name.
Yeah, good name, reputation, honor, or integrity, because the labeling is a degrading one. So of these two possible arguments, you're depriving me of the right to buy alcohol, you're depriving me of my good name. The argument from Constantino is the good name one, the reputational argument, right? And the Supreme Court makes a holding based on the reputational point. They don't say anything about a right to buy alcohol, right? Do we think reputation is life or liberty or property?
It obstructs to gain one of those life, liberty, or property, or any components of those. Yeah.
Which one?
So, for example, for liberty, if you, because of defamation, so you can't secure a job or buy a property. So essentially you are depriving someone of those factors.
So maybe the argument under liberty is bad reputation means can't do stuff, right? You can't get a job, you can't like find a partner, you can't get business opportunities, you can't get some government license or something, right? And then property, maybe there's some argument that like you have a property right in your persona. Person or something. Sort of akin to a right of publicity argument, or in fact, if you think back to like property law, if you read like the case about spleen or the case about like, your persona, Vanna White's persona, that kind of thing, right? But neither of these seems super straightforward, right? A reputation is not a liberty to do something directly. You don't really have a property right in your reputation. It seems like the right to buy alcohol would have been a more straightforward way to resolve this, but they don't make that whole, right? Okay, so compare and contrast to Paul versus Davis. So that's another similar case as the police in Louisville and Jefferson County who say, we're going to alert local merchants to known shoplifters and distribute flyers with mugshots to the local stores. And the plaintiff here is one of them. Plaintiff has been arrested but not convicted of shoplifting. And so there's a flyer in the store that says this person's a known shoplifter, and this caused them sort of personal trouble at work and things like that, right? Plaintiff's argument is pretty straightforward here, right? Like you just said 5 years earlier, reputation is really important. It's enough to give you a due process right. Court goes the other way. Why?
It's said that the reputation argument wasn't enough, that in Constantino, they had a specific sentence that said where a person's good name, reputation, honor, integrity is at stake because of what the government is doing to him. And they said that that meant that because the government is doing to him means that the government action has to actually deprive the person of a liberty that they had before. And in this case, it didn't do that. It was just the reputation and not like the purchasing of alcohol like everyone else could do.
So they kind of retroactively recharacterize Wisconsin versus Constantino, right? Like they imbue it with a significance that was absolutely not there when that case was decided, right? They say, well, it's not just the bad reputation, it's the bad reputation plus can't buy alcohol, right? Because otherwise the deprivations from your reputational damage are private actions, not government actions. And so if you can't buy alcohol because of this reputational harm, that's a due process violation. But if they just say bad things about you, but there's no legal consequence from that, not a due process problem, right? So this is the basic holding of this case. It's called stigma plus. You need two things under this line of cases to make out a life, liberty, or property interest. You need some kind of government stigma. And you need what? How would I phrase the other half?
They call it a tangible right other than just the property or liberty.
You must lose some kind of tangible, not necessarily right, but some kind of tangible government benefit, which might be broader. So after this retcon, this is the rule in these line of cases. Why is the stigma part important? Why not just, if we're gonna like rewrite Wisconsin after the fact, why not just say that it was entirely about the loss of the right to buy alcohol? And the stigma part doesn't matter. Yeah.
It's about what the government did to this person, and what the government did was provide like a stigma to this person by characterizing them as one way or the other.
But the government also said you can't buy alcohol.
Well, because they gave them the stigma.
Well, I mean, if they had just like privately distributed a list that said like, don't sell these people alcohol without putting the sign up, same effect on her, right?
I think by altering her status, by stigmatizing her in the community, that was what ended up depriving her of the right to purchase alcohol back in Constantino. So I think that's why they focus on that as well.
That's a major factor to the court, right? So the court says on 381, the stigma resulting from the defamatory character here was doubtless an important factor in evaluating the extent of the harm worked by the act. And under Goldberg, the test of whether something was life, liberty, or property depended in part on this balancing of the individual interest versus the government interest. And the individual interest is way higher if the harm is not just you can't buy alcohol, but also the government's going to talk shit about you, right? Yeah.
I mean, in a way though, isn't it like putting a posting of like known shoplifters prevents you from buying anything? Because the store owner might just deny you entry into the store.
That's kind of my next question, right? Like, doesn't the known shoplifter post do the same thing? Because like every store that has that is going to be like, please leave the second they see you, right? Is it going to have the same effect?
I think the distinction the court makes though is that in the alcohol case, the government was the one saying, don't sell this person alcohol. Whereas in the shoplifting case, they were just providing shopkeepers with information to do with what they please.
So that's absolutely the distinction the court is going to rely on, right? So in Wisconsin, it's the government saying you can't buy alcohol. In Paul v. Davis, it's the shopkeepers making an independent decision. You're not allowed to buy here, which they're totally allowed to do. But like arguing back against that, like if the court says what matters here is the extent of the harm might be similar. Yeah.
And they also made the distinction that these were official acts, that being arrested was an official act rather than drinking at home. So like, that way the want, it's not an official act.
So maybe that affects the harm if like, the harm is,
Well, it's like the sex offender registry, like that's allowed because they're officially documented criminals, and so it's public record. Meanwhile, drinking at home every night, a bottle of wine every night is not official record.
true. So maybe, this is a distinction I don't think the court really relies on, right? But like the habitual drunkard is kind of an opinion about like not violations of the law, right? Like a thing that you have a private right to do versus shoplifting, at least the person's been arrested, although not convicted.
There's also a distinction in the manner that the two types were gone about. So there was a posting for everyone to see in the stores for the Constantino case. And then, for the shoplifter case, it was just given to the storekeepers and they didn't disseminate that information at all.
Posting that everyone can see versus things that only the shopkeepers can see. So maybe the extent of the stigma is different. Possibly. If no stigma was required, then the other big distinction is that would require holding that there is a due process right or a liberty interest in buying alcohol, right? And that would be sort of maybe a more dramatic shift than any of this due process stuff that's actually about process, right? That would be kind of a holding about a fundamental liberty interest under the substance of the due process clause that the court was probably not willing to do, right? That would say that anything that's not unlawful to do, actually you just have a legal right to do, right? It would mean that like if the court, if like, a government-owned concert venue deprived, like said, we're not going to give you another drink because you seem to be too drunk or something, right? There'd be like a due process right there, right? That would be a very dramatic holding. And so this version where they have a stigma requirement plus the loss of some tangible benefit is in some sense a more restrained holding because it's going to like disrupt fewer things, right? Okay, so takeaway from these two cases. One, this represents sort of a trend in this area of the law where in the 1970s, we saw the courts expand this idea of life, liberty, or property after Goldberg to cover things like welfare benefits, and then in Wisconsin to cover like government defamation that says you can't, drink alcohol because you're a habitual drunkard. And then within a few years, we see the courts start to carve back at that, right? They're sort of retconning the Wisconsin case to say, no, it's about this stigma plus test that they just made up, right? In a way that means that just a pure defamation claim is not going to be viable. And that's a consequence in part of the fact that these cases really turn a lot of the time on how you frame the right at issue. So the fact that the plaintiff in Wisconsin versus Constantino framed it not as the right to buy alcohol, but as government defamation led to some consequences a few years later that the court was not willing to forego with. And so a lot of these cases, you can frame it in different ways or at different levels of generality and get different outcomes that way. Questions on that before we turn to Roth and Sinderman? Yeah.
Well, I just fail how to see how there's a question of, I mean, a lot of towns publish arrests and charges in the daily paper. So isn't this like public domain information anyways? So just because they compile it, they're not really doing anything.
So that's probably why, like, the court was not willing in Paul v. Davis to say, no, you know, just making a public statement about someone is enough to bring up a due process right? Because like, if you just publish like a police blotter, police log, like, that's fine because you might be imposing a stigma, but there's no tangible government benefit that goes with that, right? Whereas if Paul v. Davis went the other way, like even posting wanted signs might be a violation, right? That's probably one the police would be willing to do because like the only way you can assert like, no, it's a violation of my due process right to post that wanted sign is to show up and say, hey, wait a minute, then they'll arrest you, right? For the thing you were wanted for. But yeah, so the government was, or the court was not willing to say just government saying bad things about you is enough to give rise to a claim under the due process. Yeah.
Would it make a difference if a person is convicted? Would it make a difference if a person is convicted, like, because they're already provided due process for that, or would that be like a separate action, so therefore would need a separate due process?
Would it matter if the person was already convicted because presumably during that conviction they got due process rights? I mean, I guess the question is, would it count as a stigma if it's the government like saying something that is indisputably true, right? Potentially it still could. So like, you know, the government said, well, people who have in the past been convicted of X are no longer allowed to, you know, buy alcohol, right? This will come up in all of the sex offender registry cases, most obviously, right? Where if in the past you were convicted of this, now you have lost this tangible government benefit of not having to go around and tell all the neighbors, right? But in those court cases, the court said it was okay because of that due process the first time. So maybe it doesn't count as a stigma. Other questions? Okay, so thank you, Ms. Nagamoto. Nagamoto?
You're right.
Nagamoto. Thank you, Mr. Shuchi. Thank you, Ms. Looney. Let's turn to Regents versus Roth and Perry versus Cinnamon. So this is got Ms. Klein, Ms. Is it Solon? Solis? Okay. And Ms. Yunus, is that right? Yunus. Okay, so another pair of related cases, right? So we've got two cases, both involving faculty at universities who were fired or effectively fired. And in one they win, in one they lose. So starting with Regents versus Roth. Roth is given a one-year teaching contract, not renewed. And so the district court ruled in Roth's favor. Why? The district court, not the Supreme Court. Yeah.
The district court said that the teacher's interest and reemployment at the university was greater than the university's interest in not renewing his contract. And so in that weighing of interests, he won.
So pretty straightforward application of this Goldberg balancing test to decide if something is a life, liberty, or property interest. Weigh the person's interest in it against the government's interest in not providing process. And here, someone has a really strong interest in their job. So reappointment is a life, liberty, or property interest, right? easy opinion to write. You have a recent decision from the Supreme Court that gives you a balancing test to look at. So why the reversal? Why does the Supreme Court disagree? Yeah.
It says that it's not going to look at like a weighing of interests, and instead it's going to look at the nature of the interest that's at stake. And so its question is like, is the interest here within the liberty and property? It says no.
So it's sort of the court backing away from the only thing we care about for life, liberty, or property is this balancing test, right? The court instead is going to say, actually, there's like content to those words. We look at if something is a liberty interest worth protecting under the Constitution, or whether something is a property interest, or I guess a life interest. And those are categories, not just a term of art that means things that are really important to people, right? And so this is neither. Why? Why is it not liberty?
Because the state didn't make any charge against him that would actually damage his standing and associations in the community. And they didn't impose any kind of stigma or other disability that would prevent him from getting another job.
Stigma with no stigma plus, right? Or no stigma, but a plus, right? Which of those is it here?
I don't think there was any stigma because they did not make any charges against him. And he still had the liberty to contract. So I guess no stigma, but possibly stigma plus.
Is there a loss of a tangible government benefit?
No, because he wasn't entitled to be rehired.
So wasn't entitled to being rehired, but he was definitely deprived of his job, right? Yeah.
Well,
yeah.
the court says that it was a one-year contract, and the only thing that the contract itself called for his termination at the end of it, and that it didn't entail them rehiring him at all. And so they said that's not a government benefit. That
So,
under the
yeah.
property, it's not what's preferred.
So the liberty one is a little weird. We'll come back to that in a minute, right? But it's no property because why? Say it again.
There was no legitimate claim of entitlement, is what they say.
So there's no legit claim of entitlement because why?
Because the contract did not call for renewal, it called for his termination. So he didn't have an interest in reemployment.
So all he had was, you're going to be hired for a year, and then maybe we'll hire you again, but that's like independent of this, right? He got that year. He got everything he was entitled to. And so a property interest, the court says, is one where you have some kind of legitimate claim of entitlement to something. From where?
State law.
Yeah, from some source of state law, right? That might be like, you know, a state contract right. Or it might be like, you know, some state tenure standard or something, right? Or something, but you have to have something that you can point to as, I have some legal entitlement to this thing. And therefore depriving me of it is a deprivation of property. Sort of like in Goldberg, depriving me of my welfare benefits is a deprivation of property because I'm legally entitled to those under law. And so, like on 371, the court says the 14th Amendment's procedural protection of property is a safeguard of the security of interest that a person has already acquired in specific benefits. These property interests may take many forms, but they come from this legitimate claim of entitlement under some outside source of law. I guess it doesn't have to be state, it might also be fed. But it has to be some independent source of law that is not the due process clause. And then the liberty piece. That's where the stigma part comes in, right? So the court says on 370, while this court has not attempted to define with exactness the liberty guaranteed by the 14th Amendment, the term has received much consideration, and some of the included things have been definitively stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, blah, 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 a bunch of stuff. In a constitution for a free people, there can be no doubt that the meaning of liberty must be broad indeed. There might be cases in which a state refused to reemploy a person under such circumstances that interest in liberty would have implicated, but this is not such a case. The state, in declining to rehire the respondent, did not make any charge against him that might seriously damage his standing and associations in the community. Had it done so, this would be a different case, right? So under the stigma plus test, the court says no stigma, but yes, you're losing a government benefit, right? If they had said bad things about him as they didn't renew his job, this would be a different case, the court says. Or this may be a different case, right? So what does that say about a tangible government benefit?
Seems like it's pretty easy to meet that requirement.
Yeah.
Liberty is broad.
It's pretty broad. And then they cite Wisconsin versus Constantino for where a person's good name, reputation, honor, or integrity is at stake because of what the government is doing to him. Notice and an opportunity to be heard are essential. So a tangible government benefit does not have to be a property right. It can be broader than that. Because if it was limited to entitlements, then we don't need stigma plus. You always just win on property, right? So the loss of the tangible government benefit can be pretty easy to satisfy. You were paying me before, you decided to stop. Even if you have the legal right to stop, the fact that you decided to stop while also smearing my good name, is a stigma plus issue, right? That's in fact the next case, Perry versus Sinderman. Yeah.
So what if the employee were put on a do not rehire list? So each next employer you try to get, it's not a public reputational slander, but it does hurt his employment chances going on.
So if so he didn't get his job renewed,
right,
and they put him on a do not hire list. How does this affect him to other employers?
Yeah, because there's not like a public stigma. His reputation in the community isn't hurt, but it does hurt his employment or employability chances later in the future.
How? What's the mechanism?
Well, when you apply to a new job, they ask for references, you give them your old references.
That's key. If the reference said, we are not going to rehire this person because whatever, or because they've been put on a list of people not to hire, that would count as a stigma. That is why most companies have policies that are like, the only thing we will do in a reference is verify that someone worked here, because of exactly that concern. Either if they're government because of this, and if they're not government because of defamation liability. So that kind of reputational harm would be enough. Yeah.
When you say loss of any tangible government benefit does not have to be property, Do you mean that it could be an abstract idea?
No, it still has to be tangible. But it can be the loss of something you don't have the right to. If that makes sense. So, like here, the person has no legal right to their job. But if they weren't rehired and they also were smeared, the court suggests that would be a different case. So, like one example, let's say, you're applying for, like, the government is going to hand out like parking spaces, right? There's like 5 really cool parking spaces at the public university. The government's going to hand them out. And you have no entitlement to one, but you don't, or like you have had it for a year and then like they redraw every year. You don't get it back. And when you don't get it back, they said like, we took your name out of the drawing because you parked poorly. That would be the loss of a tangible government benefit, even though you don't have any entitlement to it. Does that make sense? I can't tell, I feel like the room is more confused than normal. I'll try to go back and re-summarize them more, yeah.
The example that you just gave, from the point of view, for the purposes of stigma, does it matter if I just tell you this is the reason, you, the employee, or if I tell everybody?
No, it would have to be someone in the broader community. And the reason we know that is, so then the court talks about like, there's no suggestion that the state, this is spanning 370 and 371, in declining to reemploy the respondent, imposed on him a stigma or other disability that foreclosed his freedom to take advantage of other employment opportunities. They didn't invoke any regulations to bar the respondent from public employment. Had they done so, this would be a different case. And so what the court is saying there is like the injury from the stigma is how it affects your employment going forward, right? Other public employment, maybe other private employment as well. Other universities didn't want to hire you. So it would have to get out to that community in some way. It doesn't necessarily have to be public. Like the postings, that are sent to shopkeepers and kept in the back at stores might be good enough. But anything that affected your reputation would be enough for the stigma part. Or that affected how other people think of you. Yeah.
I'm just confused whether the court is referring to this employment that the person currently has as a tangible government benefit, or is it the possibility of a future employment which would be affected by the stigma, which would be lost?
That's a good point. I think here the court is referencing the job that is not being renewed, which is the one they've had for the year. But if they didn't have that job and like they were an applicant and they just weren't hired, could that be enough? Maybe. That seems like it didn't help. Let me erase this and sort of draw a chart. So this is sort of a chart of things that give rise to due process claims, things that are deprivations of life, liberty, or property, right? So 1, welfare benefits, definitely yes, right? 2, anything that is sort of a pre-existing property interest protected by the common law is still going to count, right? So like taking away your land, taking away money, taking away, stuff like that, right? And then we get into these sort of cases that are starting to be a little weirder. So from Wisconsin versus Constantino and Paul V. Davis, we have stigma plus, which requires some sort of government stigma plus loss of some tangible benefit. So you can't buy alcohol, or you're no longer going to be employed, right? And then from this case, we have a sense of property that is based on some kind of existing legal entitlement, right? And so welfare benefits are going to be an example of that. And this legal entitlement is from some law other than the due process clause. So that'll be like state law, state contract law, state, employment law, federal law of some kind, right? Some kind of legal source you can point to say, I am legally entitled to this job, or I'm legally entitled to this money or something, right? There is overlap between these. So welfare benefits, an example of property, common law interests are an example of property, right? But stigma plus, the tangible benefit is broader than just property rights. Or existing legal entitlements. Because otherwise the stigma part is pointless. You already have a property interest, right?
Isn't it pointless anyway though, but it's like if it augments like what wouldn't otherwise be considered property, then it has to be some kind of liberty or property to augment that. And like if they could augment each other to become something, then you'd have to think there's some sort of liberty or property anyway, just less simple, right?
Well, maybe it kind of depends on what we think life, liberty, or property means, right? And so there's sort of two ways to think about it. One is we're looking at what counts as life, what counts as liberty, and what counts as property as like separate classes. If we did that, welfare benefits are probably a property right. Common law interests are probably property interests, right? Legal entitlements are a property right. And under that conception, stigma plus is probably a liberty interest. Because in Wisconsin, the court characterizes I can't buy alcohol anymore because they smeared my good name as an interest in liberty, right? What else would be a liberty interest protected by due process? You're getting into con laws. Why? Privacy? Why?
I don't know, I just was thinking of that, I don't know what case from privacy in the marital bedroom.
Yeah, right. So like there's a fundamental liberty interest in marital privacy or in the right to marry in the first place or in the right to raise your children. So the court, like I read a few minutes ago, talks about these cases, right? That there are certain classes of things like, the right to marry, to establish a home and bring up children, et cetera, that are protected as due process, even without stigma, right? And so those are sort of fundamental liberties. So those are another category that are protected under due process here. Where, like, if the government said, like, you know, you've applied for a marriage license and we don't like your name, and so we're just gonna say no. Right? That would be a due process violation. Because there's not necessarily any stigma plus, but it's a deprivation of a fundamental liberty. Is this helpful? I think this is all the categories we're going to talk about. There might be, I mean, I guess there's also life, right? Like, the government can't unilaterally murder you if you are not an enemy combatant, or something, right? I think this is going to be all our categories. And like I said, there's some overlap where, like, these are basically just examples of legal entitlements. So in that sense, we're going to have property is existing legal entitlements. Liberty is going to be either fundamental liberties or stigma plus. And then life is life. And so in this case, then, there is no property claim because there's no existing legal entitlement to be rehired. And there's no stigma plus claim because, yes, you lost a tangible benefit, but the government didn't say mean things about it, right? Yeah.
My confusion comes into where there's a loss, because if Paul said the contract ended, if it after the fact no longer exists, how are you losing it?
Yeah, so that's a good question, right? So what is the loss if the contract has ended? What are you losing? Arguably nothing. But if the normal practice was you have a one-year contract and most of them are renewed, then maybe in fact you have some claim that you had an expectation it would be renewed. It's not a legally binding entitlement, but that might be in practice how it works. It typically is.
When I read it, I thought about how like the other half of this case is that he had a First Amendment claim also, and so he was sort of saying like I didn't get hired because of these things.
Which we're completely ignoring because the First Amendment is not due
Yeah,
process.
so but the court knew that, so that could like to me, I thought that might have been where that sense of loss came from.
Yeah. That's possible. Yeah.
Just want to ask a clarifying question. Is this a government action because it's a state university? If it had been.
Yes. All of this is only relevant because it's a state university. Private university, this whole case immediately loses. So, thank you. Really important point that I didn't make that I should have, right? This only matters because it's a public university. But it follows from that it would also apply to any other government employee, university or not, right? Which is what the court is going to say in Loudermill in a few cases. Let's talk about Perry. Yeah.
So for the case of Liberty, so at least one branch of the Liberty goes again to the property because most of tangible benefit could be construed in light of losing a property or an opportunity for future employment, right?
Well, so, okay, so could the loss of a property interest count as losing a tangible benefit? Yes. But then you don't need to do stigma plus because you just went under property.
But it's a two-branch thing. So for stigma plus, so because of defamation, so I don't know, I can't find a place to go, and all these things can be categorized under liberty, fundamental liberties. But at the same time, there is another branch that goes to the property. So deprivation from future employment. So I do see that as a property. Is it correct?
I'm not sure I agree with everything you said, so I'm going to restate it. Tell me if this helps.
Sure.
Fundamental liberty versus stigma plus are completely different branches. Fundamental liberty is going to be like things that have been protected by constitutional law, like the right to marry, the right to raise your children, the right to travel, fundamental liberties from that line of cases, right? Things that give heightened scrutiny in substantive due process cases, right? Stigma plus is going to be the things that are not fundamental liberties, where if the government imposes some reputational harm on you, and also you can point to any kind of tangible loss, even if it's one where you don't have any legal entitlement, but you might have had an expectation, like I expected to be rehired, or I was applying for a job and they didn't hire me, right? Then that would be enough. So this is, under this branch, you have these two requirements. And then you can also make a property argument. This is something that Perry will probably help clarify, right? Where this is sort of a separate argument that requires some legal property right. Does that help?
Yep, thank you.
So let's turn to Perry. Similar case, also a professor, also on a one-year contract, also a contract that was not renewed. Also says he was fired for speaking out publicly against the university. This is, by the way, not even like one of those ones where like the court's thinking shifted over time. I think these two cases were decided on the same day. So what's different here?
I guess one of the differences is this is appealed on summary judgment, so they're not actually making a ruling, they're just determining whether it's plausible, right?
So different procedural posture, summary judgment, right? So we kind of accept the facts as true in the light most favorable to the non-moving party, which here was the plaintiff. Yeah.
I think that they said that she did, or the teacher did have an loss of tangible benefit or a legal entitlement, that's one word.
Sorry, say that one more time.
That she had a legal entitlement because, well, her contract didn't have her having tenure. There was this existing policy where they just made everyone feel like they had tenure, so.
Yeah.
That's right, even though.
So just in case anyone doesn't know what tenure is the thing in academic employment where once you have tenure, basically you're entitled to continue having your job unless one of certain things happens. Like, so, you get fired for some kind of massive misconduct or criminal act, or like the school closes or something, right? But they can't fire you just because they don't want to renew your appointment, right? Yeah.
Also, the board issued a press release alleging that insubordinations.
Yeah, so we also had a press release, but hold on, I'm going to come back to that in a moment, right? So here, so in the first case, Regions versus Roth, no tenure system at all, right? Clear that this person was not tenured. So therefore, no property right because there was no legal entitlement to reappointment. Here, in contrast, there's an allegation that there is a property right, not from any formal tenure system, but from a de facto tenure system. This argument that they had this weird language that was like, we want everyone to feel like they have tenure, right? And then in practice, that meant everyone had tenure. That's a factual dispute. So the fact that it's on summary judgment matters because we have not yet resolved the factual dispute. But if there is tenure, then the plaintiff wins on this property argument, right? Because they have fired a tenured employee. And then the other difference, say it again.
Was that they issued a press release alleging insubordination, so that points to the stigma element.
Yeah, they put out a press release, so there was definitely government stigma. And so even whether or not there was tenure, there was also a loss of a tangible government benefit because he wasn't reappointed. And so under this case, we have a potentially viable claim under liberty under stigma plus, and a potentially viable claim under a deprivation of a property right, right? And so if these are independent, setting aside these two because they're duplicated, right? But if these four things are like the independent types of due process claims that you can bring. In Regions versus Roth, the plaintiff fails on liberty because no stigma and fails on property because no legal entitlement. Here, the plaintiff potentially wins on liberty because yes, stigma, yes, loss of tangible government benefit, and also potentially wins on property because alleged de facto tenure system. Now, the plaintiff only has to win on one. So now they have two viable things to go to trial on. Okay. Since we're out of time, I'm just going to say one last point on this, and then we'll start with our next case next time. Think about Regions versus Roth, the first case where we have neither of these two things true. Let's say in that case, the government had, or the school had put out a press release. Who wins that case? Answer. There we would have stigma and we would have a loss of tangible government benefits. So the plaintiff would win on liberty even if the property continued to not exist because there's no legal entitlement. So in Perry versus Sinderman, two independent ways to win, either one of them would be good enough. So if you have a scenario where only one of them is true, still a viable claim. If that makes sense to you, you understand all these cases. Okay, see you not Monday because we have a holiday, right? We'll see you a week from today. And have a great holiday.